Welcome to Canadian Justice. I'm Christine Van Geyn. Today, we're talking about what happens when a young person commits a serious crime and how they're treated by the justice system. In Calgary, 2 teens have been arrested following the killing of a police officer on New Year's Eve. One of the teens is 19, and the other was just shy of his 18th birthday when the killing took place. The prosecution has said that they will seek adult sentences for both boys. Their car was pulled over at a traffic stop by Sergeant Andrew Harnett. The older boy had outstanding warrants for previous offenses, and it's alleged that the younger boy was driving. After Sergeant Harnett pulled them over and began issuing a ticket, the car took off. Sergeant Harnett was somehow attached to the vehicle, and he was dragged for 400 meters as the car reached speeds of up to 90 kilometers an hour. It's alleged that the teen driver tried to push the officer off the car, and he was eventually flung into oncoming traffic. Tragically, Officer Harnett has died from his injuries. Both boys have now been charged with first-degree murder. The charge is automatic when a police officer is killed. The younger boy, who was driving, can't be named because he was under 18 when this happened, but he's now since turned 18. It's rare for prosecutors to seek adult sentences for crimes committed by minors. The Youth Criminal Justice Act covers the prosecution of youths for criminal offenses, and it does permit the court to impose an adult sentence when a youth is found guilty of a serious crime. Is this the appropriate case for seeking an adult sentence? And why are young people treated so differently by the criminal justice system? And what does this mean for victims, especially victims of violent crimes? Today, we're going to be digging into these questions and more. We'll be joined by Lozanne Wambach from the Canadian Crime Victim Foundation to talk about the impacts of violent crimes, including crimes committed by young people. Lozanne, thank you so much for joining us. Now, you're the mother of a victim of a violent crime, and that's what inspired you to create your foundation. And your son was the victim of a terrible assault. And the assault was committed by other teenage boys. So you know firsthand about the type of violence that young people are capable of committing. But before we get into all these questions, I just wanted to ask how your son John is doing today.
Jonathan is brain injured as a result of the attack, and there are many problems that we have to contend with. And unfortunately, it's not going to go away. This is going to be lifelong.
Yeah, I'm so sorry for what you've gone through. And it's incredible, the organization that you've put together to speak up for victims. So could you talk to me about the impact that violent crime has on victims and also on the families of victims?
Yeah, and that's actually the first thing I should say is that the family members of victims are also victims. They are also in the same category. Oh, the impact is incredible. It's just, it's hard enough to deal with the loss of a loved one due to natural causes. But when it's a violent crime, it makes the whole situation so much harder on the family members of homicide victims, and harder also on the victim, surviving victim, who has his life compromised. His or her life is now forever compromised. There are issues. There's first financial issues. For example, in the case of the story that you're covering, the husband is often the primary breadwinner. So what does the wife do after? I mean, she's financially compromised. There are issues of the children who have nightmares, who are so afraid that they're going to lose the other parent, who have so much post-traumatic stress. There's so much to contend with. There's also, in the case of siblings of the homicide victim, they are often neglected by their parents unintentionally. It's just a burden of grief on these parents. The victim who had his life forever compromised has so many issues to contend with. And these are issues that they have to live with. There are dire needs for counseling. And yet, although the criminal gets counseling paid for, they get free counseling. the victim also often has to pay for their own counseling. And I know this personally.
Lizanne, thank you so much for sharing your perspective. And unfortunately, that's all the time that we have. But thank you so much for joining us today and for everything that you do for victims of crime. Welcome back to Canadian Justice. Today we're discussing crimes committed by youth and when youths are sentenced as adults. Joined by me now are three legal experts. Mary Birdsall is a lawyer and executive director of the Justice for Children and Youth Centre. Dr. Nick Bala is a professor at Queen's Law, and Ari Goldkind is a criminal defense lawyer. Thank you all so much for joining me today. Ms. Birdsall, I'd like to start with you. Can you explain to me why the criminal justice system treats young people so differently?
I think there's not only a Canadian recognition, but an international recognition that adolescents are different, not just chronologically, but qualitatively when it comes to criminal justice system considerations. So we create a unique justice system that is able to respond in effective ways to the sort of unique circumstances around adolescent behavior and criminal behavior in particular. So we consider there to be a need to create a system that holds young people accountable while also accounting for their unique developmental and vulnerable position, their unique developmental needs and their vulnerable position in society as a whole. And their vulnerability generally related to being dependent on adults for much of many things in their circumstance, and the unique opportunity that we have to be sure that the criminal justice system responds in a rehabilitative way to youthful behavior.
So, Professor Bala, when we talk about an adult sentence versus a youth sentence, what does that mean practically? Is it a different length of time or a different facility? What exactly are we talking about here?
Well, the biggest difference certainly is the length of time. So, for example, for first-degree murder, it could be life imprisonment for an adult sentence, whereas if it's a youth sentence, it would be a maximum of 10 years. And shorter sentences for other kinds of offenses. Historically, it might have affected where the young person was. And for example, in many American states, they take teenagers and place them in adult jails, which is very, very problematic. Fortunately, in Canada, it's largely only at the age of 18 or later that a youth who receives an adult sentence would end up being in an adult facility.
So, Mr. Goldkind, the case that we were discussing earlier, the Calgary teen who had just turned just shy of his 18th birthday, who was accused of killing this officer at a traffic stop, is being close to 18 a factor in seeking an adult sentence? I mean, he was just shy of his birthday. Do you think that could be playing into the decision in that particular case to seek the adult sentence?
I think it has to, or else we're really dealing with a legal fiction, the same ways that we would look at a 12, 13, 14, 15-year-old differently than we would look at somebody who is 17 years old on their 11th month and their 28th day. To say otherwise, I think, would ignore development of the brain. It would create some unimaginable made-up line in the sand between 17 and 3/4 and somebody who's 18. And as your other guests would note, the differences between somebody who's 18 in a day versus somebody who's 18 less a day is absolutely massive. So for a court to assess and make a decision as to whether or not an adult or youth sentence is the one that's going to be imposed, you would look at a sort of constellation of factors of that young man, his development, his understanding, his moral culpability, the idea of whether a short youth sentence would address all of the principles of sentencing, including rehabilitation. But in my view, to say that there would be no difference between somebody who's just shy of their 18th birthday versus somebody who's 14 and a half, to me, that's an ideological argument that I don't think somebody would succeed on.
Professor Birdsall, or Ms. Birdsall, how would you respond to that? Do you think that the courts are taking into account maturity, or do you think that the prosecutor should be taking that into account as well?
I think generally speaking, and in particular, maybe when we're talking about the potential of an adult sentence, I think that courts are obligated under the law to take it into consideration. And I think Crown attorneys are also under a certain kind of obligation to consider the circumstances when they're making some of these discretionary decisions about how to proceed. And it's certainly my experience across the board that Crown attorneys take into account all of the circumstances that are at play.
If I could just add, there is a reality that some of these age limits are arbitrary, or if you want, bright lines. And for example, if you're 11 3/4, you can't be held criminally accountable. If you're 12 and 1 day, you can go into the youth justice system. So while I agree that age is a factor, we also have to recognize that there are these limits that I should say are significantly reflective of brain development. That's something that
Professor
we
Bala,
haven't yet talked about.
Dr. Bala, I just wanted to let you finish up your thought on bright lines and maturity and when an adult sentence is being sought.
Well, there are some, as I said, bright lines that are recognized not only in Canada, but internationally in the United Nations Convention on the Rights of the Child. But really, the range that we have, 12 to the 18th birthday, although physical development for most young people will end around the age of 15 or 16, 17. Brain development, however, which is really partly what we're talking about here, will go on well into the late teens and indeed the early 20s. And so sometimes young people commit horrific crimes, but we're not holding them as fully accountable as adults, as Mary Birdsell has said, partly because we want their moral and cognitive development, but really it reflects back to their brains, and to say that they don't have adult levels of foresight, responsibility, and control. And that's an important issue here.
Mr. Goldkind, I wanted to ask, how do we protect the rights of youth while simultaneously pursuing justice for victims?
Well, a lot of it depends on your conception of justice for victims. Many people want Canada to be an eye for an eye country. Many people are constantly dissatisfied with our sentencing rules that tend to release even adults after a third. There are notorious cases where people get 10 years and then 2 years later we're having discussions in mainstream media about parole ineligibility periods. The Youth Criminal Justice Act is very significantly different from adult sentencing. Now, one of the goals of Youth Criminal Justice Act is to make the victim whole, is to make amends. There are rehabilitation and restorative types of issues. But when you're dealing with the kinds of crimes that can be called heinous or very, very serious, not the indiscretions of a youth, 2 kids at a school where one steals an iPod, oftentimes you're going to have the general public and the community involving victims to be upset at the kinds of sentences that youth courts and even adult constituted courts dealing with the youth would give out. So there is no perfect answer to this, but for the public being informed, as the professor has just told us, that one of the reasons we do this is because there is a difference in the brains between younger people and older people. But as time goes on and as the world changes, it can't just be a one-size-fits-all approach, which is why when these sentencing happens, there's an extremely detailed examination into the particular youth, rather than it just being, oh, he's 17, here's what we're going to do.
So, Ms. Birdsell, I want to follow up sort of on what Ari said here. In this situation in Calgary, the crime was obviously tragic and terrible, but it wasn't a premeditated crime. So in cases like that, is it less appropriate to seek an adult sentence when it was sort of this terrible set of circumstances that arose, rather than a planned out, thing that the offender did?
Well, there are a number of different sort of quirks in the criminal justice system where charges that you sort of hear about them on their face and they may sound one way. When you unpack them a little bit and learn a little bit more about the circumstances, they might in fact have a slightly different character or a different nature. And the specific circumstances, not only of the offense and the situation, but also of the individual person, are always relevant, whether you're talking about adult court or youth court. And so, it's very easy to make sort of snap judgments or have strong views based on a little bit of information that we might get in the media. And one of the interesting things that's in the criminology research is that the more people know about the details of cases, the more likely they are to see a judge's decision as having been fair or reasonable. And so I think it's hard when we're watching from afar, when we're not involved in the situation, to know for sure what it actually is fair. And I think there is reason to be cautious, but also to be somewhat confident in Canada that we have a fairly thorough mechanism for evaluating the circumstances of individual people who are charged with crime. And what we really should hope for, in my view, is that we really do a thorough job of trying to understand where that person has come from, what kinds of things are influencing their behaviors, not only in the moment, but generally speaking, how their maturity and their intellectual and cognitive development is impacting their decisions and what's happening. So, I think it's undoubtedly true that the details of the circumstance will matter a lot. And sometimes when something is charged as first-degree murder at the outset and the circumstances with the police officer, I apologize, I'm going on, but there's a lot going on there, and we have to be cautious when we're acting.
Thank you so much. We're just going to be back from a break from our sponsors. Welcome back to Canadian Justice, where we're discussing youth sentencing. And Dr. Bala, I wanted to start with you. Could you tell me how common it is for prosecutors to seek an adult sentence for a young person? Is this something that happens rarely, or is it a relatively normal part of procedure?
I should say, whether we don't have great Canadian data on this, and there are many issues we'd like to know more about, but it's very clear that it's a rare occurrence, and I should say much rarer in Canada than in the United States. And I think that's a very desirable thing for society as a whole. But there are other countries that also have very low rates. Many of the Scandinavian countries and European countries would have very, very low rates because in the youth justice system, we have facilities that are focused on rehabilitation of young people. And although not all young people can be rehabilitated, many of them can. And ultimately, rehabilitation is the best protection for society. And it's also, of course, nothing can ever bring back the life of someone who's dead. But in the criminal justice system, we're trying to weigh various factors and take, account of the horrific crime and the cost to the victim's family, and of course the victim, but also say what's in the long-term interests of society and what's a fair and appropriate thing, taking account of the fact that the young person has lesser maturity, different brain stage development from an adult.
So that's a really great point. And Ms. Birdsell, I want to follow up on that. Since the Act does have a focus on rehabilitation and reintegration, how's it doing? What are the recidivism rates? Is the Act working?
Yeah, I think that, Professor Bala's point is a very good one, that we are really lacking a lot of Canadian data on things. But I think the general consensus is that the youth criminal justice system is actually working very well. We have had a falling crime rate in Canada for both adults and young people over the last 2 decades very consistently. And we know from the research, both Canadian research and American research, that rehabilitative measures with young people work very well. And that, in fact, rehabilitative measures in a youth criminal justice system that's specially designed for teenagers work much better than punishment in the adult system. So there is much reason to be very confident in a separate youth justice system as the best way to protect the public and to respond to youthful crime, even serious crime and devastating loss. And I think that the short answer is yes, the youth criminal justice system and rehabilitation approaches are working very well.
And so this is the third iteration of youth justice legislation. We had the Juvenile Delinquents Act, then the Young Offenders Act, and now it's the Youth Criminal Justice Act. Dr. Balla, do you think we're getting it right now?
I think that we certainly have a much better system than we used to have. We used to send a lot more young people into custody for nonviolent offenses. So it's been a really big improvement. And as Mary Birdsell's pointed out, we've actually seen a fall in the level of youth crime. I think we also have to be realistic that not all young people can be rehabilitated. We may not know in advance when we're sentencing who is going to be rehabilitated. So dangerousness, future risk, those are legitimate factors to take into account, especially around adult sentencing. But I think we have a system that has seen a lot of improvement and stands up very well, as Mary says, internationally compared to some other countries in terms of their youth crime rates and how they treat and rehabilitate young people.
Well, I want to thank you both so much for joining me today. It's been a really interesting discussion about a very incredibly serious topic. So thank you both so much for your time today, for contributing to this conversation.
Thank you.
You're very welcome. Thanks for having us.
We've heard today about the tragic case involving the killing of Officer Harnett in Calgary during a traffic stop on New Year's Eve. His life was taken, and the lives of his family will never be the same. The alleged killers were young, but just a year apart in age. Does that justify the criminal justice system treating one as an adult and the other as a child? The prosecutors in that case don't think so, which is why they've sought an adult sentence for the teen defendant. We've heard that there are reasons young people are treated differently. Adult sentences are imposed rarely and only in exceptional circumstances. There's a strong focus on rehabilitating young offenders, and the law itself takes into account that many of them come from complex and troubled circumstances. Imposing an adult sentence on a young offender won't bring back the victim, but in some situations, it's the right thing to do. Is this one of those cases? You be the judge. I'm Christine Van Geyn, and remember, a freer Canada starts with you.